Constance M. Sullivan, v. 5 Acres Realty Trust.
Mr. Lewin.
Thank you. Good morning. May it please the court. I will begin with the 93A verdict under count 4, and specifically the issue of whether under Lantner versus Carson and under the applicable standard of review, the sale of the Gagliardi's home was an isolated sale of a private home, not in the ordinary course of business. It is our contention that this was an isolated sale. The evidence at trial was that in the course of 39 years, from 1974 to 2013, the Gagliardis sold only one property, a two-family home, to their daughter, Maria, in 2003. The Gagliardis' history of home ownership is that beginning in 1974, they lived in two homes for 14 years each, converting them each to two-family homes and keeping them for rental income. In 2002, the Gagliardis bought their home in Dover. And
Mr. Lewin, I think it would be helpful if you would point out what the legal parameters are of the thing you're challenging. You're saying the evidence was not sufficient because of why? What is it that the plaintiff had to prove and didn't prove?
The plaintiff had the burden of proving that this was, under Lantner versus Carson, an isolated sale, that this was not an isolated sale of a private home, and that this was in the ordinary course of the business conducted by the Gagliardis, in order to fall within the definition of trade or commerce under Mass General Laws, Chapter 93A.
Okay, thank you.
The home in Dover was sold after the Gagliardis lived there for almost 11 years. The sale was at a loss of $300,000 compared to the original purchase price.
Mr. Lewin, how many homes did they convert into rental properties, and how many times was the client who did the mortar business involved in sort of doing work on those homes?
They converted two-family homes. They converted two-family homes. They were single-family homes converted to two-family homes. They purchased a third three-family home. And there were renovations done to the two conversions. And building permits.
I don't understand what you mean by the renovations to the two conversions. You mean the multiple family homes?
They were single family homes converted to two-family. That was what I meant by conversion.
And did your client do the renovations himself?
I believe he did the masonry work involved in the renovations on the two-family homes.
So I guess that's, and so assuming all those facts are true, is that it's still a motion to dismiss should have been granted, or summary judgment should have been granted on those facts where they are sort of, they're not just sort of normal homeowners. They're sort of normal homeowners who are doing some personal renovations and then some conversions. I guess that isn't enough to get you into the business context, I take it you're saying.
That's correct. That should not be the standard for whether or not the sale of a home.
So then, are we at the point where it's really not so much a question of whether the evidence was sufficient at the trial, but really that in any view of the light most favorable to the purchasers, there's not enough?
That is correct. That is correct, Your Honor. That is our view.
And if that were not true, I mean, not that that were not true, but if that were not, if the standard is not if we conclude that the motion to dismiss was properly denied or the summary judgment was properly denied, then we're left somewhere with a quantum of evidence issue. Is that correct?
That is correct.
And then if we look at that quantum of evidence, what is it that persuaded the judge, and what is it that persuaded the jury to hold against your client in terms of that quantum of evidence going over to business?
I believe that the jury conflated the business of apartment rentals and the business of masonry construction with what occurred at this property. I believe that the jury was angered by the failure to obtain a permit for renovations done some 7 years, almost 7 years prior to the sale. Renovations to the kitchen and to the porch, which were done for the purpose of providing a place for hosting family and friends.
Would they have had to believe that the purpose was resale, or could they have accepted that the purpose was to host family and friends and have a more enjoyable kitchen?
I do not believe that even if the purpose was for resale, that should be sufficient, or that should be acceptable evidence.
So then, if I'm following that, then what they wanted to do it for was irrelevant in your mind, but the jury was angry about the failure to get the permit.
Correct, and then the structural deficiencies that the Gagliardis admitted were present as a result of the repair effort. With respect to the improvements, I think there's millions of homes in Massachusetts. People make improvements when they go to sell, when they're about to sell their home all the time, paint the house, remodel a bathroom. I don't think that the fact that improvements are made here 7 years prior, but even if they're made in connection with a home, that necessarily converts the sale of a home into a business, because it would create an untenable standard.
Mr. Lewin, I know you want to focus on this one transaction, but does it not at all matter that the defendants here were in the masonry business, right? And several times have purchased, renovated, and rented out homes over the last several years? Isn't that something to consider?
I don't believe it matters in connection with the sale of a private home. If you conclude that this was an isolated sale of a private home, and they were not in the business of selling houses, renovating and selling houses, then I think that if you create a standard that says, well, let me look at what other businesses that they were in and see if there's a connection between those businesses that they're in and the isolated sale of their home, then and I'm going to say then that every home that is sold is subject to General Laws Chapter 93A, well, then that would require the court to look at the experience, knowledge, and sophistication of a broad range of people. I mean, attorneys know that you're supposed to get building permits when you do renovations to your home.
Mr. Lewin, let me ask you about this part of the case where the spouse did the books for the masonry business in the house and some of that. Where would that lead us in today's world, where most people have, well, not most, but a lot of people have home offices, accountants, lawyers, and the like, doing Zoom calls out of their homes, right? Shouldn't we look at that and when we're considering whether or not that converts a primary residence into a place of business?
Yeah, yes, Your Honor, it would create an untenable standard, because you would, every transaction, a home sale would be scrutinized to see what degree did people work at home, especially now, and what were they doing in their house, what were they using their house for. I agree with that point of view. Here, Mrs. Gagliardi worked in the home for 2 to 4 hours a week doing the books for the masonry business and for the apartment rental business.
Mr. Lewin, could I ask you please about the implied warranty of habitability, and on the same issue you've been on about a single transaction, and the issue is whether Albrecht versus Clifford should be extended to this situation. And what I mean by this situation is you've got a contractor who is aware of a latent defect that resulted from that contractor renovating the home. Is that a natural extension of Albrecht that we should consider as it relates to the implied warranty of habitability?
First, Your Honor, I believe the evidence is that the defendants were aware that they failed to obtain a building permit. They had done these renovations for themselves. They were not aware that there were structural defects to the porch renovation and to the kitchen expansion. But putting that aside, I would suggest that the standard for extending or for applying the implied warranty should be limited to those persons in the business of developing residential property for resale. The builder, in other words, the builder vendor. Once you extend it beyond the builder vendor, then I think that you get into an area where the standards become very blurred. And then anyone with some knowledge and experience and knowledge of building permits, such as a real estate attorney, could then be subject to the implied warranty for the failure to obtain a building permit.
Mr. Wu, can I ask, Mr. Justice, are you done?
Yes, thank you.
So, Mr. Wu, I know you're a construction lawyer, so, and there's something about this case that troubles me because it seems like it's odd. I mean, in an ordinary, so we've got people doing renovations in a home without getting a license. How do you normally sue and recover for that? I understand we've got this sort of oddity here. We've got this 93A claim based on they're in the business. We've also got this implied warranty of habitability. If this were, there's got to be some way of recovering for doing construction in a home without going to the building inspector, and then you get stuck with this house. How would this normally have been dealt with? This seems an oddity. I'm just trying to understand in conventional parlance, there's got to be a remedy for a wrong. I'm just trying to understand conventionally, how would it have been dealt with?
Your Honor, I would say conventionally it would be dealt with a purchase and sale agreement that contains provisions relating to the discovery of latent defects, instead of releases, as we had in this case, a purchase and sale agreement that released the seller from all liability. There was the second belt and suspenders.
No, but I'm trying to understand. So some contractors, you're quite familiar with contractors. Some contractors and also your client built without a permit. Your client also knows he shouldn't build without a permit. I'm just trying to understand, as a conventional matter, how do you recover if you end up with one of those homes? Is 93A the conventional way this is dealt with, or implied warranties of habitability? What is the sort of standard way we deal with these kinds of, basically improper conduct? You can't build without a building permit, right? So I'm just trying to understand, you say this isn't applicable. I'm trying to understand how it should have been remedied, because there's a wrong here, right?
That's correct, Your Honor, and it should have been remedied through the terms of a purchase and sale agreement, breach of the purchase and sale agreement, if they're in terms of a purchase and sale agreement.
No, but there's negligent construction, right? No one knows negligent construction better than you, right? This is negligent construction, but we don't have a negligence claim here, right? I'm just trying to, this just seems very odd, this case. I can't get my arms around why it's odd, but
yeah.
But there's got to be a remedy for a wrong. There was construction done on a house without getting a permit. So is 93A not the way to do this? What is, should the contractors have been doing? I'm just trying to understand conventionally, how do you recover for this wrong? Particularly when your client, who's a builder, does it without a permit. So I'm just trying to get a sense of, I don't sense the equities on your side, but I'm not sure these theories are correct.
Your Honor, the remedy is through the contract, through a purchase and sale agreement that protects the buyer with representations that appropriate permits were obtained. And in fact, the Greater Boston Real Estate Board standard form of purchase and sale agreement has a checklist that includes a representation that permits were obtained for all construction.
But so you don't, when a builder builds without getting and going through the building inspector, and the house ends up getting lived in and sold, you don't have a negligent construction claim?
No, I apologize, Your Honor. If your focus is on the builder,
Well, but your client is also a builder. He did some of the masonry work, right?
my client does masonry work, yes, foundations.
But he knocked down the wall in the building, right?
The carpenter that he hired knocked down the wall, yes.
Okay, all right. I'm not getting anywhere, but
May I ask you a question, counsel? I think one of the answers Justice Kafka may be looking for is that the regular route would be prevented by the statute of repose. Is that right?
Yeah, that's what I was getting there, but yeah.
Okay. And so if that's not available, then going to the claims that the judge did dismiss, breach, the fraud and the misrepresentation, what was the theory under which those were dismissed?
The law on fraud and misrepresentation with regard to, as applied to the purchase and sale agreement, is that there is no duty to disclose there's no duty to disclose the absence of a building permit.
Okay, and so really your theory, putting everything else aside, I agree with Justice Kafka. It doesn't look like the equities are good for your client, but the law might not get the other side where they want to be. But here, a typical way to approach this normally would have been to sue on the basis of the contract violation on the purchase and sale. But you're saying in this case, there were separate releases instead of the typical language in the purchase and sale that released your clients from all liability.
That's correct. And then there was a clause, and there was an inspection done by the buyer, and the inspector told the buyer.
By the buyer said, "Hey, check out. We didn't look at the permitting history. You should do that." Basically.
Yes.
Any further questions of Mr. Lewin? Thank you, Mr. Lewin. Mr. McGuinn?
Thank you. Good morning, Your Honors, and may it please the court. Taking up the questions posed by Justices Kafka and Seifer, under this contract, there would have been no remedy. And the remedy here is based upon two things, Your Honors: latent defects, number one, and number two, defects that were concealed, defects that were illegal. In this particular instance, the remedy, putting aside Chapter 93A, is breach of the implied warranty of habitability, for the simple reason that an exculpatory clause or a release in a contract is not going to bar that type of a remedy.
I find that really odd. I mean, I understand the 93A claim, but I mean, the breach of the implied warranty of habitability, they lived in the house themselves for a long time, right? I mean, so I'm not handy, but say I were like Justice Gaziano, I'm a very handy homeowner, and I make improvements to my house. And then down the road, I sell the house. I'm, you know, I live in it for years.
Gaziano got all the permits he needed.
Yeah, but I'm just trying to understand how we've got an implied warranty of habitability here. A lot of people work on their homes. It just seems like that's a real reach.
Justice Kafka, that is not this case. Obviously, somebody that goes down to Home Depot on the weekend and gets a new kitchen or a new bathroom and remodels it, that's what did not happen here. What we have here is evidence that was presented to the jury during this 9-day trial, that not only were the Gagliardis engaged in trade or commerce under 93A, but they were also builder vendors. We have a gentleman, Mr. Gagliardi, who had a construction license for, I believe, 50 years. He also owned his own masonry business. He also qualified and was registered as a home renovator. So we have construction knowledge and experience. We also have Mrs. Gagliardi, who was part of that business, managing it from the Dover home. So we have one of the elements we think of builder vendor here, this experience, this expertise. The jury also heard, Your Honors, that Mr. Gagliardi in particular performed a fair amount of the renovations to the kitchen and the so-called Tuscan room himself and with his son. He used equipment from his business, J&F Contracting, to perform some of that work. He also...
Mr. McGlynn, and again, I don't mean to be difficult. I'm just trying to make sure that we don't convert every, homeowner who goes to Home Depot into an implied warranty person. I understand they did some work in converting some homes into rental units, but how long do they live in this Dover after the renovations, before they sell it? They live for how long?
They acquired the property in 2002, I believe. They began renovations, Justice Kafka, at approximately 2006. Those renovations were completed in 2010. We don't know the exact date because Mrs. Gagliardi spoliated crucial evidence relating to the renovations.
But they live in it. They live in, while those renovations are going, I take it they're living in the home they're like Thomas Jefferson. They're living in their house while they're constructing it, right?
That is my understanding, Your Honor. And once those renovations were completed in 2010, in May of 2011, less than a year later, they put the house on the market with an asking price of about $3.3 million, or roughly $1.120 million, over what they purchased it for in 2002. The point is that that's only one of the factors that would determine what we would submit is a pervasive element of commerciality in terms of what they did here. This was, Justice Kafka and Your Honors, I believe the fifth property where what we discussed and presented to the jury during the trial was the Gagliardi's business model. Putting aside the fact that they were operating their two businesses, the construction business and the real estate business, out of the Dover property, and they stored equipment there. There is a clear record.
Can you go back to that storage of equipment issue for a moment? Reading the record, it seems to me that there's some conflict. That your argument is that they're storing all this equipment there. The other side's saying, look, it just happened once or twice a year when his jobs were close to home, he kept his truck there. What's the resolution of that?
Considering the standards of review of this case, Justice Cipher, if there was conflicting evidence on that, the jury was certainly free to choose to reject that. It was only here a couple of weeks. And under the standards of review, Justice Cipher, the contrary evidence should be rejected and not considered. So the jury certainly took that into consideration, not only the trucks that were stored there, but also the scaffolding that they used to install the chimney and some of the foundation work on the so-called Tuscan room. So this business model extended for approximately 4 decades. And they had a cycle where they would acquire a property, they would renovate it. As my brother indicated, I believe in 2 properties, they expanded from 1 apartment to 2 apartments to double the rental income. They did that repeatedly. They used the equity in these properties to acquire additional properties. They used the equity of those properties to acquire Dover. And
did they ever live in those homes? I understand.
Yeah, yes, they lived in.
Yeah,
Yes, they did, Your Honor. Yes, I'm sorry, I didn't mean to talk over you. It's a little bit of the electronic transmission. No, as we stated in our briefing papers, the evidence was that they would stay in a home, not every home that they acquired, but for approximately 10 years. During that time, they'd renovate them. They'd then live in them for a while, and then they would put them into.
Can I be more specific? Because
Certainly.
so let's just focus on where and I don't mean to mispronounce the name, the Gagliardis lived their whole life. Forget about their children and other things. So they lived in how many, because I'm sure Mr. McGuinn, you've probably lived in 5 houses. A lot of us have moved and, benefited from the going up in the market. I just want to make sure we're not writing decisions that apply to everybody here, but something specific, because a lot of people improve their homes, move to a better home, they improve that home and they move to another one. I just want to make sure we're not sweeping in those people into a 93A claim. So just tell me, how many times did the Gagliardis change homes? Go ahead, over their lifetime here.
I believe, Your Honor, that they changed homes approximately 4 or 5 times. They lived in 2 of the rental properties in Newton, which they renovated. Mm-hmm. Then they used the equity in those rental properties to acquire a commercial property, which obviously they did not live in. They used the equity to acquire the Dover property, which they did live in. And
is that different from a normal people who are successful in the world and they're making a little money and they're buying a little bigger house? Are they really different from just what a lot of people want to do, the American dream, go from one house to another that's a little better than the house they were in before?
This is not a case of the American dream where they've had some good luck in maybe capitalizing on a hot market. This is something that they have done over 40 years, where they would renovate. They would improve the value of those properties. They would pull out the equity from those properties to acquire other properties. They would take that equity and use it to renovate. Dover was within that chain. I believe it was the 5th of the 6 properties that they acquired. They then used the equity in Dover to acquire Weston. They moved out of Dover to Weston at the time that they sold the house to the Sullivans in 2013. There is evidence, Justice Kafka, that they considered renting out Dover, but they decided not to do that because of its remoteness and its size. It was going to be a difficult rent. But what they did do is, while they were finishing the renovations in Dover, they used the equity from Dover, they acquired Weston, they renovated Weston in 2009, and they used that and generated approximately $36,000 worth of income annually just from that one property alone. Again, this rental income, from the evidence presented to the jury, was well over 50% of the total income that these individuals received annually. It was disproportionately rental income as opposed to salaries. They also obviously achieved significant wealth by virtue of the increase in value of these properties as they were renovated.
You recognize in Dover that they lost about $300,000. But let me ask you this, because I want to come at this from a different perspective, because you've been asked a lot of questions about, and so is Mr. Lewin, about, is this the right cause of action here? And we've got a statute of repose that's complicating it. But one could argue that what's going on here is trying to chisel in this circumstance into a course of trade and commerce. And I know that the fraud case was dismissed, but why isn't this fraud? You've got fragmentary information, at least. The United States Supreme Court once said the best way to lie is to surround truth around the lie. I don't understand why, instead of, well, I do understand, because you got attorney's fees and multiple damages, But it seems to me that the real gravamen of what's going on here is fraud. They decided to talk and not say the real big thing, which is not only do we not have a permit, but we got structural problems here. And by the way, we're contractors.
To address your question in twofold manner, Justice Lowy. Number one, the fraud count was dismissed. We do think that there was actionable fraud, and that was the basis of one of our cross appeals. There was actionable fraud under Canavos versus Anino here, based upon the representations and the marketing materials touting these renovations, obviously without disclosing no permits and defective construction. And also when Mr. and Mrs. Gagliardi separately escorted the Sullivans around during the pre-closing inspection. And Mr. Gagliardi is promoting the renovations he made in the so-called Tuscan room. Mrs. Gagliardi is promoting the renovations she made.
Well, but they're proud of, I mean, I guess a couple of things. One, they like them. You know, they're proud of this room. They've lived in it. Whether they know I mean, if they knew it was structurally deficient, they're risking their own lives living in there. So I guess, Mr. McGlynn, none of us trust the person who sells us our house. That's why we hire building inspectors, and have the termites person come. I'm not sure this is fraud, as opposed to, they're not. I don't see this necessarily as fraud. Isn't this what the building inspector is supposed to pick up? Your client is also a sophisticated business person who can afford a building inspector. They must look at it and say, wow, this wiring isn't right. I don't know. It just seems like this is tricky, this thing.
Well, yes, there was a building inspector here, but the jury heard the testimony from the building inspector. The jury heard the testimony from the Sullivans as well as the expert witnesses. And whether or not the building inspector's testimony may have been consistent with what you're suggesting, Justice Kafker, the jury had every right to reject that testimony, and it should not be considered for purposes of the standards of review, which cabins all of the evidence that we have in this case. The evidence that—
Mr. McGlynn, can I ask on that point, and again, this is in your favor, so let me finish the question. So did they move to dismiss the 93A and the implied warranty of habitability claims when they were originally brought?
If I understand your question, Your Honor, via, for example, a motion to dismiss or summary judgment?
Yeah, was it? I
Twice.
take it.
Twice.
They tried. They tried.
Twice.
Okay.
Twice they tried, and they failed. We are up, as you are well aware, on two motions: motion to alter or amend, or a motion to new trial. The justices are certainly much better aware of what the standards are there. The evidence here is we think substantial of not only trade or commerce, but builder vendor. I just want to get back to one thing, and that is we do not—
Your time is running out, so be quick, please.
All right. We don't believe that there's any legal floodgates that are going to— litigation floodgates that are going to be open here, because a plaintiff is going to have to demonstrate each and every factor for a breach, for example, of 93A or violation of 93A or a breach of the implied warranty. Builder vendor, causation, damages, statute of limitations, statute of oppose. Thank you.
Thank you, Mr. McGlynn.